Nothing in the Lou Brydges Show is intended to be legal analysis, legal advice, or legal recommendations that would be applicable to your particular situation. Everyone in foreclosure or underwater with their mortgage are encouraged to seek legal counsel for a review of your specific situation. Welcome to the weekly broadcast of the Lou Brydges Show, telling the truth about the foreclosure crisis and the greatest financial crime in history that created it. Are you in foreclosure, at risk of foreclosure, or underwater with your mortgage? Do you know someone who is? Every week on this show, you'll get real answers from a real attorney. Lou Brydges will explain options in the foreclosure process and talk about defective mortgages, mortgage restructuring, loan modification, short sale negotiation, and discuss what to look for when choosing a foreclosure defense attorney. Lou is an experienced foreclosure defense lawyer on the front lines of mortgage defense and litigation. Lou's dedicated to helping you keep your property. And now, it's time for the Lou Brydges Show and the truth about foreclosure. Here's your host, Lou Brydges.
Good morning, Chicago. This is Lou Brydges, the Lou Brydges Show, and boy, what a week we've had. I want to thank everyone for all the positive feedback we've been getting, and apparently the show is starting to reach some listeners, and that was the whole purpose. Our purpose is to spread the truth about what the major banks in our country are doing today, and as always, we start out every show reading the prophecy that was given to us by one of our founding fathers, Thomas Jefferson, that is perhaps no more relevant than in today's time. But Thomas Jefferson said in 1802 there was a little bit of financial crisis in the country. Apparently these financial crises are not unique to our times, but as we all know, they come and go. But Thomas Jefferson wrote in 1802, he said, "In light of the current financial crisis, I believe that the banking institutions are more dangerous to our liberties than standing armies. If the American people ever allow private banks to control the issue of their currency, first by inflation, then by deflation, the banks and corporations that will grow up around the banks will deprive the people of all property until their children wake up homeless on the continent their fathers conquered." Well, this is a warning, not a prophecy of what ultimately would definitely happen, but what could happen if we, the people, allow it. And that's the reason for the Lou Brydges Show, because we, the people, need to start standing up and doing something to stop this. And there are a lot of people around the country are doing that more and more every day. The news this last week, I thought last week's show had a lot of news developments, but this past week has even surpassed that. Let me just first go through our news segment. Reported in the American Banker, Wells Fargo and Citigroup halt most foreclosure sales as the Office of Comptroller of the Currency ratchets up scrutiny. Wells Fargo and Citigroup have halted the vast majority of their foreclosure sales in multiple states following the release of new guidance from the Office of Comptroller of the Currency. The abrupt showdown comes in response to the OCC's April release of minimum standards for foreclosure sales, which are usually the final act in the foreclosure process. Let me just add, usually the final act. There is always an appeal process. The Federal Reserve has issued identical guidelines to the banks it oversees. Within 2 weeks of the release of the guidance, Wells Fargo, Citi, and J.P. Morgan Chase all but stopped foreclosure sales. Because that's what we've been saying now for 5 years. These major banks are the servicers of the mortgage. They don't own the mortgage, and they've been serving it in a way that is profitable for them, but contrary to regulations and standards, and they've been perpetrating frauds upon the court across our nation. That's what the independent foreclosure reviews that the OCC allowed the banks to conduct. The banks thought that they would, by controlling the review process, they would be able to whitewash all the abuses in the foreclosure process. And let's since this show is about the truth, let's call these abuses what they are: frauds upon the court, crimes that are being committed on a daily basis in the chancery courts across our country by the major bank servicers. Wells Fargo temporarily halted foreclosure sales while they study the revised guidance. The guidance is that you should use the truth. No robo-signing, no fabricating of documents, no forging of documents, no falsifying assignments and transfers of the mortgage. Because the thing is that people need to understand about securitization is the banks, the major 12 banks that services mortgages in this country, they do not own the mortgage. It's owned by either the Fannie Mae, Freddie Mac, FHA, or a private securitized trust. And in all instances, restructuring, that is a modification with reduction of principal balance, would be better for both the lender and the borrower. And the lender, the mortgage has been paid off by either private mortgage insurance or these credit default swaps. So the investors, which are largely public employee retirement funds, have not lost any money. The banks are making tremendous profit by servicing these mortgages in a manner in which they just foreclose. That is why they sabotaged all the efforts at loan modification, the HAMP program, which is an abject failure, and all the other programs they sabotage because they're making a profit by foreclosing on homes. The fees they charge are 30 times those of a performing mortgage. And then when the house sells, they collect the money there. But going on with the news release here, the robo-signing debacle was the only other time we had a similar event where banks slowed down significantly. The thing is these independent foreclosure reviews, as deficient as they were in their methodology and as cherry-picked as the ones they reviewed, they found fabricated documents, false assignments, and there's been whistleblowers that have now come out, and they talk about warehouses where people are doing nothing but forging and recreating history because there was a failed securitization. Now, what this means is that if you're facing foreclosure, if you're underwater, or even if there's been a foreclosure judgment, but there hasn't been a sale yet, there are things you can do if you have a competent legal counsel. You can file motions in court. You can slow down and halt the foreclosure process, and at the same time apply for modification and restructuring. And if you're underwater, there's something called the strategic default, which is coming into vogue, which is I want to talk about from a moral standpoint, but is an option that you can stop the situation where you're overpaying. If you're $100,000 underwater, you're overpaying by almost $1,000 per month for the mortgage. And the reason you're underwater, I had a conversation with a modification representative of one of the banks this week, and he wanted to reserve the right to, it gets complicated, but basically he said, well, in case the market comes back, let me tell you something. The market didn't drop. The market corrected. There was an artificial balloon that was created by the Wall Street investment banks that were bundling and packaging mortgages. So they were giving every incentive to the originators to produce mortgages that were as much as possible. And thus the appraisers and the originators put through mortgages that caused an 131% increase in the cost of American real estate from 1998 to residential real estate from 1998 to 2008. This created $5.5 trillion of paper that was sold to investors that doesn't really exist. I mean, the value wasn't there. So I'm falling a little bit behind here. Elizabeth Warren, another news report. Elizabeth Warren pushes the feds for answers on big bank enforcement because it's out there. These independent foreclosure reviews, as suspect and as whitewash an attempt as they were, revealed mass fraud by these servicing banks, which means that if you're a homeowner, there is hope. You just need competent legal counsel. Every one of these cases, there's still 20 million people underwater. Every single one of them is going to have to be addressed individually. The New York Attorney General is revising the foreclosure settlement and has filed a complaint against Bank of America and Wells for violation of the foreclosure. And the reports go on and on. The purpose of this show is to advise the public because I think there is so little information out there about the options that homeowners have that are facing foreclosure or underwater with their mortgage, or even where there's been a foreclosure judgment entered. And even if there's a sale imminent, there still may be hope. Illinois is a judicial foreclosure state. The foreclosure has to be reviewed in court, and the judges are starting to see that they're not happy about this fraud that was perpetrated upon them. They put too much trust in the foreclosure mill attorneys. And these foreclosure mill attorneys are starting to squirm because they're being asked, why didn't you inquire of your client about this? Why didn't you find out? Why didn't you check? Because you have a duty as an attorney when you present something in court that it's got to be, the truth. I'll tell you a little story when we come back. We're going to break for sports and weather. I'll tell you a story about what happened today. Just this morning. This show is taped, but it's just this morning on Wednesday. We're going to start doing the show live next week, by the way. But what happened just in court this morning, I'm going to give you I'll give you a little case history. It's very interesting, And the foreclosure mill attorney was squirming because the judge was asking him, my client received a check from the independent foreclosure review. And so I wanted to reopen the judgment. And the judge is going to grant that motion. He's going to give them time to look into it. But the foreclosure review found that there was some fraud upon the court. We have hundreds of clients that received these checks for everywhere from $300 to $2,000, in one case $20,000. And it just says the independent foreclosure review found some abuse of the process. But they didn't tell us what abuse. And the truth needs to come out, because the lies will eventually bury themselves. But we have to go after the truth, because the truth is there is mass fraud being perpetrated by the homeowners in this country by the major banks servicing mortgages. I'm Lou Brydges. We're going to break. We'll be back in a few minutes. Be sure to stay with us. We got more.
Welcome back to The Lou Brydges Show with Louis Brydges, one of Chicago's leading foreclosure defense attorneys. Here's Lou to tell you what to look for when hiring a foreclosure defense attorney and how to avoid being conned on AM 560. The Answer.
Good morning, Lou Brydges again. I'm going to get right back into I was telling a story before we broke about what happened in court to me this week. And I was representing a client that the lawsuit was filed in 2008. And the bank got a judgment, a default judgment, based on a phony service of summons. The process server claimed that he served this woman, and we had a time card that showed that she was at work at the time, which is very typical. We find that a lot. So anyway, we moved to get the judgment vacated, and for some reason the judge who was hearing the case then denied that motion. So we have grounds for appeal. So whatever happens in the circuit court, we're going to appeal. But we know the client, we've been fighting the case and applying for modifications, and so the client's been living there for 5 years by just paying our monthly fee, which is a pretty good deal, but it's not an end game. And we do have, obviously, the appeal from the judge's, what I think is erroneous ruling on our motion to what's called quash the purported service of summons, because we had proof that she could not have been home at the time the process server claimed to have served her, because she clocked in at work. But you see, back then the judges were kind of thinking, well, it really doesn't matter. It's a note, it's a mortgage. But in any event, so now the client gets 2 checks from the independent foreclosure review, $2,000, with a cover letter saying that these checks are a result of a settlement with the Office of Comptroller of the Currency, where we conducted these independent foreclosure reviews. And we found in yours some errors or some abuse or wrongful processing or servicing of the mortgage. So she brought this in, and what does this mean? I said, well, cash the check. And then we filed a motion in the court to vacate the judgment. And we said, actually, we're not asking for a hearing on this motion. We just want time to conduct what's called discovery, to ask them to produce what abuse of process did you find. And the judge said, yeah, I can see where that would be relevant. He said to the foreclosure mill attorney, he says, do you know anything about this? And he said, no, I don't. He said, well, don't you want to inquire? Because, you're representing a client that has written the defendant and told him that they abused some process at court, and you're the attorney for them. I would think you would want to find out too. And of course, at this point, the attorney saw the writing on the wall, and he said, you're right, Your Honor. Perhaps we should continue this hearing. And so we got a continuance to July so that I can send out a request for documents, and I want to see what the specific independent foreclosure review report for this particular, and I know they're going to fight on that, and then we're going to have motions to compel. And at the same time, though, we're applying for a modification. And now, because we've got some ammunition, guess what? They're going to be a lot more receptive to this application for modification, because things aren't going quite so well in court. It's no longer a rubber stamp foreclosure. And, this could go on for another couple of years. And they see that we're going to have an appeal. So we talk to the people at the modification department, and we say, this house is $100,000 underwater. We want a modification with principal reduction. Now, we've had about 20 cases so far this year in which a similar situation, and we're getting a new response. The response, when we say we want a modification with principal reduction, the response has been, how much? Now, you have to understand that I think it's very important that we take the very high road. I don't want to get anybody their house free without a mortgage. I don't want to get anybody anything they're not entitled to, but The homeowners were the victims of a fraud in the origination of the mortgage, in the appraisal, and the way the mortgage was, sold and assigned and transferred, and in the denial of applications for modification. So what I say in these cases is, we'll get a current fair market appraisal. You reduce the mortgage to something a little bit under the fair market value of the property, say about 95%, 90%, and the homeowner will make a payment next month. And you're the owner of the mortgage, because remember, the bank is just a servicer. They don't own the mortgage. The owner of the mortgage is now going to have a performing note and mortgage that is fully secured, and have a homeowner in there that's got equity, maybe only 5 or 10% equity, but you can be darn sure that if the homeowner's got 5 or 10% equity, they're not going to miss any payments. If you're $100,000 underwater, well, quite frankly, you're paying the taxes and you're overpaying to live in the property. You could rent the property for a lot less than your mortgage, and you're 25 years away from having any ownership interest, which is why I think we're going to see strategic defaults on a massive scale, because any economical advisor will advise you that, overpaying by $1,000 a month to live in this house is, some would say, economically foolish. Others would say it's stupid. Now, I understand you may have kids in this local school and you want to see them graduate, and they have their community affairs and activities. And then that's what we're all about at my law firm that I put together with Scott O, is maintaining the community, keep people in the house, do anything to keep people in the house. There's got to be a solution other than evicting people from their residence. And if people are willing to pay for the fair market value, pay a mortgage based on the true fair market value of the property, and they have the ability to pay, then foreclosure is not the best option for either the owner of the mortgage or the homeowner. And that's why we fight the lawsuit, not with the intention of getting the case dismissed with prejudice, although some of them have been, and a lot more will be. When these judges find out that there was fraud perpetrated upon the court, they're going to start entering orders dismissing the case with prejudice, which means homeowners are going to own their home free and clear of a mortgage. And that's happening around the country in a lot of cases. Just happened last week out in Colorado. And it's going to be happening more and more as a sanction. But the true end game, don't hire a lawyer because you think you're going to get your home free and clear of a mortgage because the bank, even if the bank did commit some fraud, but what you should be looking for is a mortgage based on the true fair market value of the property at a reasonable, fair interest rate, and a forgiveness of the arrearage, because the arrearage came about because, in most cases, because of the house being overvalued by the originator and the appraiser hired by the originator that you paid for. And one final thing, I want to clear up the notion that so many of these loans are liar loans or that. There's no such thing as a liar loan. The originators are there to review tax returns and pay stubs and everything else. And we have seen a lot of applications that are all prepared by the originator, given to the homeowner at the time of closing when they've got the application and 50 other documents to file, in which the $80,000 income that was put in there was somehow changed to $180,000. And all the tax returns and all the pay stubs and everything else shows $80,000. When you're a homeowner and you've got a professional broker from like a Countrywide or a Taylor Bean Financial, which are no longer in business because of all the frauds they committed, and they tell you, look, we can get you this 0% loan, you can afford this house, and when the interest rate kicks in 2 years, we'll get you another 0% loan. The homeowner has a right to rely upon that independent broker who is an expert for mortgages. And if he says that you meet the guidelines, and if he says the appraisal was conducted in accordance with standards and this is what it's worth, and he says that this is what the payments are going to be, and in 2 years when the interest rate kicks in and the payments go up, come back and I'll get you another 0% mortgage, and you'll have you'll walk out of that closing with some cash. Well, that is all a fraud. And when that fraud induces, and the fraud is for one purpose and one purpose only, to get the homeowner to sign their name on a note and mortgage for the property. And that is what this is all about. All of this whole mass fraud in the securitization started with two things: the homeowner's signature on the note and mortgage. When the homeowner signs a note and mortgage, those two pieces of paper, the note and mortgage, become worth the value of the mortgage. They're sold on a secondary market for whatever their face value is plus a premium. And so it's not surprising that these investment banks that were putting together these mortgage-backed securities would compel the originators to do anything they could to get as many mortgages as they could for as much as possible, regardless of any relation to the true value of the property. Because they're going to make a bigger commission on bundling and packaging the thing. They're going to buy a credit default swap, betting that there's going to be a large number of defaults, because that's like betting on the sun rising in the east. And the servicing banks are going to make more money servicing mortgages in foreclosure. And you may say, well, what about the investors? The investors were protected by either private mortgage insurance or the credit default swap. So this is a blatant land grab by the and it's a huge profit center, this foreclosure business for these major banks that are servicing. But they're being caught now, and they're being called to account for their lies and misdeeds, because every lie requires 3 lies to cover it up, and eventually the lies will cover it up. And I tell all our young attorneys, we have but one weapon, and that is the truth, and that's all we need, because the truth will eventually come out, and the truth is what our justice system should be based on, and we as lawyers will demand that it be based on. And you, the people, need to stand up and make the same demand. Countries don't fail because of evil people. Countries fail when good people do nothing. So stand up and fight for this country. Don't let Thomas Jefferson's warning come to be. This is our land. I'm Lou Brydges. We're going to break now. Come back. Stick with us.
Louis Brydges of the law firm Brydges & O and Associates, one of the leading foreclosure defense firms in the Chicago area, rejoins you now on the Lou Brydges Show. Here's Lou on how you might avoid foreclosure and deal with a mortgage that's underwater.
Welcome back, listeners. I'm Lou Brydges. Of course, I've got Mike Main here, and my lovely producer, Debbie Schreiner, who is going to be with me. No, even when we go national and get syndicated. In syndication, I'm sticking with Debbie. I'm demanding that she go with me. She rise to the top with us. Anyway, Mike has gathered some questions that we've been receiving, the typical questions from listeners and some of our clients and people who call and inquire. And the show is supposed to be about what you might do and what to look for in hiring a foreclosure defense attorney. So, Mike, what are some of the questions you have here?
Well, hello, Chicagoland. I've been getting a lot of calls, as you know, Lou, and I've kind of tried to paraphrase several of these questions that I get over and over, slightly different form from different people. Very typical. I applied for a modification a while ago, and my bank approved me for a trial modification. 6 months later, or sometime later, they denied me for a permanent modification. Now I find that the foreclosure case has been moving along without me, and I'm afraid it may be too late for me.
This is called dual tracking, and we must have 200 cases that have involved dual tracking. It's also called sandbagging. The trial modification they don't want to flood the market with too many foreclosures at the same time, so they just, it's a scam to try to get you to make 6 months of payments. And, if you're approved for a trial modification, well, what changed? Why do you not get the permanent modification? Well, the reason is they've collected 6 months more of principal, interest, taxes, and insurance on the property, and they haven't flooded the market too much with the foreclosure. But at the same time, they've got you ignoring the foreclosure. And all the judges will tell you that it's a different proceeding. It's a dual track. The modification is outside of court, but the court proceeding is not theoretically stayed. Though there are some regulations that say that if they're in a trial modification, they're supposed to treat the loan as if it's in forbearance. And but we see oftentimes that the homeowner says, well, I talked to the person I was dealing with in the modification, and they said, don't worry about the lawsuit, you're in a modification. Meanwhile, the attorneys who don't know anything about the modification or claim not to know anything about the modification have been pursuing and getting a judgment of foreclosure. And then you got a situation where the judgment of foreclosure is 6 months old. The person finds out that the house is scheduled for auction, and they hire us, and we go in to file a motion to vacate the judgment. And the judge says, well, this judgment was entered 6 months ago. Where you been? And you kind of, well, the homeowners were told they didn't need to worry about that foreclosure, and the judge said, well, they did. This is a legal proceeding. And, that's happening less and less because I think the judges are starting to see that this was a tactic to basically sandbag homeowners and to collect as much as they could. And then they want to have a steady stream of the foreclosures because otherwise they flood the market. So what's the next question you have here?
Okay, I found...
but there is an answer. We've come up with this motion. It's based on an estoppel theory and a detrimental reliance, and we're not only having some success with that motion, but even if it's not right. And there's got to be some method in the law that you can present some sort of argument. If something is done wrong, there's got to be some way that you can present it to the court, and we're having more and more success doing that. What's the next question you have?
Along similar lines, I found out that the bank has obtained a default judgment. However, I've never been served any specific papers. Is that okay?
Yeah, well, if I had a dialer for every case, for every one of these I've heard. The process servers, they don't use the sheriffs in most cases. They use their private process servers. The private process servers are paid based on the number of supposed services summons that they do. And, we see, I can't believe it, but we do see these fabricated all the time. And the other thing they do is they'll serve by publication, because they'll say, well, the process server tried to serve 3 times and then nobody was home. And so, we believe that they've left the jurisdiction, and then you can serve by publishing in that section of the newspaper that nobody has ever read or nobody ever does read. And it turns out that the process server went out there at 10 o'clock one day and 11 o'clock the next day and 12 o'clock the next day, and the person works from 9 to 5. So, that's very typical. I had one recently in which the process server said she's avoiding service because when I rang the doorbell, I saw someone inside and they went up the stairs. We went to court. We brought a picture of the house. It was a ranch. Go ahead. What's the next question? We only have about a minute and a half left, so one more quick one.
It's kind of quick, but we'll see if we can get through it. I would really rather move anyway. Is there anything that an attorney can do for me, or should I just try to work directly with the bank?
We have different programs. One is Save Your Home, and the other is Sell Your Home. And it may involve fighting the foreclosure and then putting the home on the market. And then when it sells, you need some relocation expenses. Don't just do a short sale and turn over all the money to the bank. Because, the part of the value of that house came because you've been taking care of it. And people that want to give up their home, we can use it. It's called cash for keys. Or other times we do a short sale and we take $10,000 or $15,000 and we can save that for the homeowner for relocation expenses. And that's we're having more of those. People that are having trouble finding work here, maybe going to Texas or something. I don't think you should give up on the Illinois economy. I think it's going to revive. And anyway, so we're going to break now. We're going to come back for another segment of sports and weather. Important thing is never give up the land. This is never give up the land. It's always been about the land, because the land and liberty are inextricably bound. And you take away the land, you take away the liberty. So fight for truth and justice. You'll never be alone in this country.
We now return to the Lou Bridges Show, telling the truth about the foreclosure crisis and the greatest financial crime in history. Here's Lou Bridges, an attorney on the front lines of the ongoing battle for our land.
Welcome back to the Lou Bridges Show. We're covering some questions. Mike, my sidekick here, has been reading some questions that are typical of the questions. He's paraphrased. He's put together 2 or 3 questions. It's sort of like poetic license. And so if it's not exactly the way you worded your question when you sent it in, don't worry. We're going to tell you in the closing segment where to send questions, what websites to look at. We're going to give acknowledgments to our sources. But right now we're getting a little pressed for time here. So, Mike, what's the next typical question?
Okay.
Paraphrase.
I may be underwater, and it may be a bad deal. However, I feel compelled to try and pay as I agreed to in a contract, my mortgage. Why would you tell me not to?
Well, I wouldn't tell you not to. I can't make a moral decision for you, but I can point out to you some things that you might consider in making the moral decision yourself, because it is basically you're talking about, and this is the kind of client I like. I want somebody that's, thinks the moral issue through. I've thought it through, and I've come to my conclusion about this, but I'm not going to tell you what to do. But let me point something out to you. If you have been fraudulently induced into signing into an agreement, is that agreement enforceable? Well, it's not enforceable in court if you've been fraudulently induced, and I don't think it's enforceable morally. I came up with an analogy. Suppose, somebody came to you and said, hey, I've invested with this guy, Bernie Madoff. It's a great deal. He's a really cool guy. He makes good returns. But you have to have $50,000 to invest with him. But I told him you're my friend, and he says if you pay $10,000 a year, he'll let you invest. You sign an agreement that you'll put in $10,000 every year, and he'll waive the $50,000. So you sign an agreement to invest $10,000 a year with him, and you do so for the first couple years, and then you find out that the whole thing's a fraud. Do you have an obligation to continue to pay him the next 3 years until he's caught, or even after he's caught? You make your decision on that, but I will say that I think that what's important is your family and experiences. You know, all this stuff, the money and the houses and everything, one day they're going to be absolutely worthless to you. But you will have what you did in life, people you helped, the things you did with your family. And I see so many people that are so strapped that the kids can't do hockey because it's expensive, so they have to find another sport, or they can't take piano lessons, or you can't go on a family trip together because we're so overburdened with the mortgage. You know, that really is what bothers me. That's really why we're doing what we're doing, because these people, they're being deprived. You know, it's not the $1,000 a month that they're overpaying on their house. They're losing something that, in my view, is priceless. And that's why I really am upset with these major banks that are serviced. Not so much that they ripped off people with their money, although that's certainly something to be upset about. It's that they're stealing lives from people. And that's why, and maybe this is all ultimately, a good thing, because it'll bring the balance back. And it'll start to bring back what's truly important. And, this all started when the big banks squeezed out the local community banks out of the mortgage business. And, by consolidating everything. And, and basically, the Thomas Jefferson Warning, they created this $5.5 trillion of capital. It's like issuing currency. When you overvalue 56 million residential mortgages by an average of $100,000, that creates $5.5 trillion of capital that doesn't really exist. But you sell it to investors because you get those two pieces of paper that are worth $5.5 trillion collectively, more than they're really worth. And you sell those to investors. And then you buy a credit default swap betting that there's going to be a default. So I think we have time for one more question. You let me get rambling on this, and I'll go on forever, Mike.
Right. Okay, and this one's a little bit different. I have some money, and I have some significant assets. Yet I realize that I'm still significantly overpaying for my property. Bankruptcy seems like a possibility, yet not desirable. What do you suggest?
Well, bankruptcy is not I'm not we work with bankruptcy attorneys, and it is an option, something to pursue for some people that have gotten themselves through loss of jobs and overextended on credit cards and things. But it's not going to stop the foreclosure. It's going to delay it for about 90 days is all. So, and sometimes we need a delay in order to, get our footing. In order to get one of these audits that will produce the evidence that we can either raise in the bankruptcy court or when the case is no longer stayed by the bankruptcy and goes back to a circuit court, the foreclosure. But in a situation for somebody who has significant assets, well, you can't, you're not bankrupt. I mean, if you have assets, just because you're overpaying your mortgage, you're not bankrupt. So again, for that person, there's the strategic default option, and we have the method in which we contest the validity of the debt based on the information that we received from the audit, and therefore they are not supposed to take any action to damage the person's credit because of the strategic default. And when we do a strategic default, we're saying we're not defaulting. We are suspending payments while we negotiate a restructuring of the debt because I'm overpaying for this because of the appraiser that your originator hired did not conduct the appraisal in accordance with federal regulations, and that is unlawful, and that is unlawful inducement. I entered and signed that note in mortgage based on the reasonable assumption that you were doing everything legally. And now I find out, and I've got the documentary evidence here, that you committed a whole slew of violations of federal law and regulations, including the way the appraisal was conducted, the disclosures, the promises that were made to me, the things that weren't disclosed, on and on and on. So I was unlawfully induced to sign that note of mortgage. We're going to renegotiate this deal. Not a default. You can, it's maybe form over substance, but what we're going to do is while we're negotiating a restructuring through my attorney, we're going to suspend payments. Now, you can take, he's got cases that have been going for 5 years. So we're going to have one more segment. I'm going to kind of wrap things up, but just to conclude, there are a lot of answers there. I cannot address any specific situation by answering a general question. Every situation is different. Every situation involves a thorough analysis of a history, of an examination of the documents by competent legal counsel, and but don't give up the land.
Welcome back to the Lou Brydges Show with Louis Brydges, one of Chicago's leading foreclosure defense attorneys. Here's Lou to tell you what to look for when hiring a foreclosure defense attorney and how to avoid being conned on AM 560. The Answer.
Well, welcome back, folks. This is our final segment. Boy, this hour has really gone by fast. Mike read us some questions last time, and if you have questions, you can send to Mike's going to give you our website,
FightIllinoisForeclosures.com. You can also call and ask questions, whether they're specific for your case or whether you want to just ask some questions for the show. Please feel free to give us a call at 224-513-1231.
That's 224-513-1231. 224-1231. Well, that's an easy number to remember, isn't it? Jeez. People are driving, Mike. Don't you think that we could come up with a little easier number to remember?
224-513-1231.
513. 513, if you're having bad luck. 1231. All right, well, good luck with that. Anyway, FightIllinoisForeclosures.com.
Correct.
We have a Facebook page for the show, and there's all links.
We'll have all that out.
I want to call out to some sources and acknowledgments, because there are people around the country that are involved in this that are doing some tremendous work. Of course, the Attorney General of New York, Eric Schneiderman, is leading, and I know that, Elizabeth Warren's doing some fine work from the Banking Committee. Neil Garfeld is the grandfather of foreclosure defense attorneys, along with his protege, I don't know if we call him protege, Jeff Barnes. Professor Adam Levitin at Georgetown University has emerged as the leading academic authority in the field, has written extensively and testified before the House and Senate Joint Financial Crisis Investigation Commission, who adopted his testimony en masse, 200 pages of his testimony about the legal issues, in which he totally debases the entire concept, the MERS concept, the Mortgage Electronic Registration System. Anybody who has a mortgage that was given to MERS, there's defects right away. The whole MERS system was an effort to avoid recording fees. The thing is we have in Illinois, we the people constituted a government that included a Recorder of Deeds Act. And our representatives passed a statute called the Conveyances Act that says interest in real estate can only be transferred in a written form, in recordable form. So this electronic registry, and most states have this, it's called a statute of frauds. It was originated in England 500 years ago. And so the whole MERS system has fallen apart, and there's deficiencies there in the mortgages. And Adam Levitin, and there's the University of Cincinnati Law Review article, they're doing some good work, in Georgetown University and University of Michigan has some law review articles discussing the issue. And of course, Gretchen Morgenson in the New York Times, and recently this Matt Tabai of the Rolling Stone magazine is doing some tremendous reporting on the massive criminal enterprise that these major banks have become. And more is coming out. And that's the thing about the truth. And that's why it's like the sun rising, the truth sheds light on everything. And it eats away the darkness of the evil and the lies. And that's what we've got going on in this country. And so that's why we do this show, to try to spread the word, because ultimately this could be a good thing. This could bring the balance back. In the last 10 years, we've had the largest transfer of human wealth in human history to a very small number of people. Fight for truth and justice. I'll be there with you. I'm Lou Brydges, Mike Bain, and Debbie Schreiner. Thank you for joining us.
You've been listening to the weekly radio broadcast of the Lou Brydges Show with attorney Louis Brydges, telling the truth about foreclosure. Have you received threats of foreclosure? Are you in a foreclosure right now, seeking a loan modification, considering strategic default, or any other legal action? Know and protect your rights, and do not give up the land. Lou Brydges' passion is to help you keep your home and achieve your legal goals. To receive a free consultation, which may help you decide how to defend against foreclosure, understand your options, and learn what to look for in choosing a foreclosure defense attorney, call 224-513-1231. That's 224-513-1231. or visit FightIllinoisForeclosures.com. That's FightIllinoisForeclosures.com. Get real answers from a real foreclosure defense firm and discover the legal tools at your disposal. Tune into AM 560 The Answer next Saturday morning at 8 for The Lou Bridges Show, telling the truth about foreclosure.